Hey everyone, how are you? Good morning. Can you hear me? Great. Visual? Awesome. All right, sorry about the delay. YouTube, for some reason, was not cooperating with me. So we're now live on YouTube. If anybody's watching, let me know you're there. If you have any questions as we go, do ask questions on the live chat. All right? So, yesterday we did only one chapter, which was chapter 20. Today is going to be one chapter as well, chapter 21. These are long chapters. That's why I prefer to break it down into two parts, okay? So I'm going to start with today's questions that you guys submitted to Nina, and Nina submitted to me. So let's go over the questions that we have. All right, and that's too many questions, so we're going to start with the chapter. Today's chapter 21. All right, let's go. Let's see what we got. By the way, Nina, you just reached your limit for today, okay? No more questions for today. Just saying. Today I think you went overboard. But okay. Let's see. Can tenants be evicted when foreclosure occurs? And I thought when the property is sold, the buyer has to fulfill the established leases. Correct. So when it comes to foreclosures, most states, including the state of New Jersey, have some type of anti-eviction, foreclosure anti-eviction protection law. So if the tenant, let's say my house, I'm not paying my, so there's two sides of this, and we're going to talk about that in leases, in property management as well. But there's two sides of this. There's I'm losing my house, let's say, right, and you're my tenant. A lot of times what happens is tenants, as soon as they find out that the homeowner is losing the property, tenants stop paying, right? See, your duty as a tenant is to pay the current owner of record. Nobody's entitled to live for free. The same way I'm not entitled to live for free, you're not entitled to live for free either. Now, and I know your question is about the tenants, but I'm giving you both sides. So a lot of tenants, again, stop paying right away. Now, you don't know the reason why I stopped paying. It could have been medical bills that I need to pay, or collections I addressed, or lost a job, or a divorce, or death in the family, whatever it might have been that caused the hardship, and that's why I stopped paying my mortgage. But I'm negotiating with the bank, right? And you as a tenant, if you stop paying right away, then guess what happens? I'm definitely going to lose the house because now I don't have neither whatever income I had and lost the income from the tenants. So the same way you have an obligation to pay the current owner of record, let's reverse this. If you are a paying tenant, you never defaulted, you've always been on time and all that stuff, you're a stellar tenant. The new owner at foreclosure has to, according to New Jersey law, for instance, and most states again have some type of protection, the new owner of the property also has to acknowledge that there's a tenant there with an established lease. So yes, they have to keep the lease terms or the remaining lease terms. They cannot raise the rent. They cannot kick you out or evict you. They cannot do anything. They have to honor the current lease. But again, you have to be able to establish that you never failed payments, that you're not in default, that you are a good tenant, right? So the new owner, just like in a regular sale, new owner has to abide by the terms of the lease. Okay, and this is true whether it's a written lease or verbal. You can discriminate once every 2 years, 24 months, and it's federal, it's not state. States like state of New Jersey, for instance, nah, that doesn't even exist. But federal law says, hey, it's okay, don't worry about it. All right. When you do a tax defer for income properties until you die, does the payment of capital gains transfer to your heirs? So that's a very interesting question because who had the capital gains? Was it the heirs or was it you? Am I responsible to pay taxes on your gains or am I responsible for taxes on my inheritance? Okay, so there's something called inheritance tax, right? So the tax you defer, and you die. You're the one responsible for those gains. I'm not. What I'm responsible for, again, is, and that depends on state law. If you're above a certain amount, I have to pay state inheritance tax. And again, it could vary depending on how much you're inheriting. It could vary the percentage or no obligation of payment on the inheritance tax. Okay. All right. Question 301. We're almost there. Which holds more weight, federal law or state law? All right. So the pecking order is very simple: Constitution, federal, state, and then it goes county and municipal. So that's the way it goes. The lower law can never go against the higher law. So which one weighs more? I already told you. It's federal law, right? But what state law can do, or the lower law can do, is enforce the basics, right? Which is the federal, let's say in this case, right? And institute more regulations. So when it comes to discrimination, I'll give you the example of New Jersey. When it comes to discrimination, a lot of the exemptions that we have under federal law do not exist under state law. So federal law has the protections for the people that could be discriminated against. State law says, I see those protections, right? And I increase a few more. So I cannot go against it, like remove those protections that you have, but I can increase, like enforce more rules and regulations as far as discrimination. So, for example, federal law, you can discriminate on the sale of a property, right? State law in New Jersey, for instance, state law says no. You can discriminate on a rental if it's owner occupied, right? We're going to talk about that when we get to state. But that's it. I can enforce more, make it stricter, but I can never go against the higher law. Let's put it like that. Okay. Yeah, just there's a lot of government housing or government sponsored housing. If only one person needs to be 55 to live in the 55 plus, if you have a 10-year-old with them, can a kid still love there? Yeah, we'll always love the kid. Can a kid still live there? The answer is simple. If you guys remember, both the government designated, the 55 plus or the 62 or older, they can institute their guidelines for whoever can live there. They're exempt from minors, right? They're exempt from the prohibition of renting to somebody that has a family with children, right? So as long as the guidelines don't go against the urban housing, housing and urban development, so HUD, as long as the guidelines don't go against it, and as long as the guidelines of that particular community strictly state this is intended for older persons only, right? So the HOPA, right? Housing for older persons, right? As long as it's strict, they tell you that. They can also include a clause that says only for 55 plus, but a clause that says minors are okay, right? See, 55 plus community means 80% of the community is at least 55. So there's one person that's 55 in the household. That's how we'll meet the criteria. Can we have minors? Possible. Again, it depends on the particular facility or community and how their guidelines are stated. Okay. Can anyone test their water quality? Yeah. Go to Home Depot, go to Lowe's. There's a test tube there that you can test the water quality. But if you're asking that, the water quality test was mainly for, in terms of rules and regulations, is mainly for private well. So if you have a private well on-site or off-site that supplies the water, running water to your property, at closing, right, and we're going to talk about closings, right? But at closing, it must state the result of the test. And this is either at closing on a sale or closing of a rental. So the seller cannot sell and the buyer cannot buy until the results are given. Okay, but can you test your water? Sure. Again, go to Lowe's, go to Home Depot, go to any hardware store. Usually they have I think even Walmart has the the test there. No. Practice exam has to be done on the computer because I need to be able to see you, and most of the times on the phone, it switches. Like for instance, Nina, when you go type something, right? If you're on a different screen, automatically camera's off, right? So for the practice exam, I need to be able to see you like I'm seeing you now. Okay, I need to proctor. I need to see what you're doing. And some are, some aren't. Do you really need them? Some are and some are not. So the class replays are on the student portal. As far as YouTube, not to get confusing, because we repeat the classes every 5 weeks, right? So because we're repeating the classes, then I'll have a bunch of morning and a bunch of evening classes. So what I decided to do is I'll keep the live class, and then eventually I deactivate the live class and leave just the replay on a couple of classes. If you notice in the student portal, a couple of classes are the morning class, a couple of classes are the evening class. And that is determined by the quality of sound, image, material being presented. So I pick and choose which videos to put on the class replay. Okay. Wait, we reached question 997? One more? All right, cool. Any other questions before I move forward? And Ninja disappeared. There you go. In the practice exam, no. That you can do on your own. Practice exam, the link is in the student portal, and you can just do whenever you want, as many times as you want. Okay. Sorry, Nina. Not as for you, not as many times as you want, because then I already know it's going to be like going to take 1,000 tries at it. But yeah, for you it's unlimited. You guys can test as many times as you want, and there's over 600 questions, so I do recommend go over everything. Yeah, you can do it on your phone, you can do it on the computer. If it's iOS, so if it's a iPhone or if it's a Mac, you might have some difficulty with it. Unfortunately, it's a matter of what do you call cookies? Cookies is what sticks to the website and says, "Hey, you're here." That's what it is, or you've been here. So if you have trouble with getting into the practice exam, let me know, and I'll give you a different link that unfortunately, because Mac's not compatible with everything, because iOS is not compatible with everything, unfortunately I have a separate link just for Mac users. Lovely, right? Can you tell how much I love Mac? Okay. Anyway, so yes, you can do it on a computer, you can do it on your phone, you can do it wherever you want, as long as it works. For Windows and Android, no issues. For iOS, just doing another advertisement here. For iOS, always issues. Great phones, don't get me wrong. Great phones, great computers. It's just not compatible with the world. That's all. All right. Any other questions? No? And then whoever's watching on YouTube is like, I'm unsubscribing right now. Mac hater. Anyway. I don't hate Mac. I just think for the amount of money that you pay for it, at least be compatible with most of the stuff. That's all I'm saying. They're actually good phones, good computers, depending on what you're trying to do. All right, so let's go here. Then there's somebody on the other side thinking, but we don't get as many viruses as you do. Well, I've been having my phone, same Android system for over 10 years now, never got a virus. So I don't know what you guys are talking about. I mean, I also don't go to those sites that bring viruses. So maybe that's what it is. It's a user issue. All right, so closings. Any questions regarding closings? If not, then we're closing for today, and it was great seeing you. All right, here's the thing. Closings. They got three people watching. Cool. So closings. What about closings? Closings is when we make what? The agent makes what? Money, right? So do you think it's important for you to pay attention? How do we get to a closing and how do we close? Right, of course, because it's when you make money, right? Wrong. Nina, wrong. It's because at closing, the seller and the buyer accomplish what they were set out to do. In the process of helping them, we've earned money and we collect it at closing. But the main idea of a closing is to make sure that the seller sells and the buyer buys. All right? So those of you that are nodding the head regarding money, that's it. You're not taking the exam. You're disqualified. Your moral compass is completely off. But yeah, at closing is where you, I'm just joking aside. Right? The closing is where you make your money. So make sure you understand everything. Now on a serious note. If you really want to make money in this profession, make sure you understand the whole process. And until now, we've been talking about a lot of different fields. Like we talked about mortgages, we talked about appraisals. None of it that you have to do, right? We talked about a lot of stuff that's related to title. None of it that you have to do. But it's very, very, very important that you understand the basics of these things, again, because once you talk to the title company, to the mortgage company, to the attorneys and all that, you need to know what the next play is, right? You will learn this once you get into the field. But understanding these basics will help you reach the closing. Because you'll be able to say, hey, mortgage person, we have this, right? Our client needs this, or our client needs that. We have this, that it's on you. We're waiting for you. Right now, the ball's in your court. Come on, we're waiting for that. Come on, come over, right? And same thing for the title company, for the attorney. You're able to orchestrate, right, the whole transaction, because that's what we do, guys. We bring the players. We're like the coach, right? We bring the players. We know what the CEO of this team wants, which is the seller or the buyer, right? And then we're the coach. We're gonna bring the attorney, we're going to bring the home inspector, we're going to bring the title company, we're going to bring the mortgage, and we're going to coordinate and make sure everything it's properly done or in order for us to reach the goal, which is, again, the closing. So it's key that you guys understand the processes, okay? Let's talk about the closing event. What happens at the closing? So the closing event is the culmination, obviously, as I just said, it's like the end goal of the real estate transaction. And during this event, the buyer pays the purchase price and receives title to the purchased real estate. That's it. That's where we exchange money for title or keys. At the same time, the buyer completes financing arrangements, and the buyer and seller pays all the required taxes, fees, and charges. Customary practice varies from state to state, as it says, so I'm not going to go too much in detail there. But time. When do we get to the closing? Well, it depends. So right now here in New Jersey, and most of the transactions that I've been going through, it's an average of 2 months. Could it be sooner? 45? Sure. 45 days? Sure. Could it be 90 days? Sure. So 3 months? Yeah, it could be. But on average, it is 2 months, similar to what is here, so 60 days from the beginning of a contract till the actual closing. So up front, we're going to stipulate an anticipated closing date, right? So when we put an offer, we say, hey, here's the $1,000 with the offer as an example. So that's the earnest money deposit or the good faith deposit. And then here's the offer, which is a contract as an example, that says hey, I want to buy your property for $300,000 and I want to close 60 days from now on December 21st, right? So I'm stipulating upfront when do we want to close. Now again, the time I just gave you 60 days, which is the 2 months. And the time period between signing and closing is expected to be sufficient for removal of any contingencies. What are contingencies? Conditions. For instance, a buyer, one of the contingencies they have is to obtain financing, right? So the buyer has those 60 days to get the mortgage fully approved, to get the funding fully approved. Now, how do we get the funding fully approved? Well, the mortgage company wants to see usually inspections, right? So the mortgage company wants to make sure everything is good, everything is okay. They also want to make sure that it appraises, right? So during that period of time, all these things happen. Now, there might be a need, depending on what the inspection or the appraisal says, there might be a need to correct some physical defects. And now we throw the ball to the other side and say, hey, seller, there's some issues with the property that you need to address, right? So you need to fix this, you need to fix that. If the seller agrees, great. If the seller disagrees, then maybe we back out because again, it's a contingency, right? So if the inspection report was not satisfactory, we can back out. If the mortgage was not satisfactory, or we didn't get approved, we can back out, right? So what I'm trying to tell you guys is no closing is guaranteed. We're scheduling it for December 21st, but once we get there, if we get there, we might close. If not, then we back out of the deal. And even at the closing table, sometimes we might not close. All right, so the time frame is an ideal time frame, what we expect, what we would want, right? But does not necessarily mean it will happen. Sometimes because of inspections, sometimes because of things that need to be fixed, it could extend another week, another 2 weeks, another 3 weeks. Right now, for instance, here in New Jersey, there's so many appraisals happening that mortgage companies are delaying everything, right? Because they're pending appraisals, as an example, right? So I think everywhere right now in 2020, everything is delayed. I sent an application the other day that's supposed to take less than 10 days. It's been 2 months. So delays. All right. Failure of either the buyer or seller to perform pre-closing actions, right, specified in the contract can delay or terminate the transaction, as I said. Now, if the contract includes a statement called time is of the essence, all parties agree to meet the time limitations exactly as stated. So what we're trying to say is the closing date was December 21st. That means I, the buyer, need to move in by December 21st, or I, the seller, need to get out by December 21st, right? So we stipulated that time, and that time is of the essence. It must happen. If we get close to that date and there's still something pending, then the attorneys send a letter, says, again, time is of the essence, we needed to close by this date, and what happened, right? So what we're going to do is maybe, if the parties consent, right, we're going to extend the closing date to another period of time. So when an attorney issues a time of the essence, they're saying, listen, we should have closed on this date. I'll give you an additional 2 weeks, but that's it. After the 2 weeks, if you don't close, I'm walking away, right? If you guys remember in contracts, we talked about breach of contract, legal breach or illegal breach of contract. A toe, as we call, time is of the essence, so toe, right? Imagine stumping your toe somewhere, right? That's what it is. It hurts, right? Because once this is issued, there's pressure. That's what it is. And you have to comply with that, or they walk away. And they can still sue you for those delays. Location. Where do we close? Anywhere. Wherever the parties agree. The closing can happen anywhere. It could be happening at the title company, the attorney's, seller's attorney, the buyer's attorney, another attorney. It could happen at the broker's office, whether it's the selling broker or the buying broker. Anywhere. You want to meet at the house? Let's meet at the house. We close there, and this way, buyer is already here, and seller, we can just kick him out. whatever we want. It's an agreement. The contract specifies the location. So there's no specific place to close. That's what we're saying. No specific place. There's nothing predetermined in law that it must happen here. Nope. Anywhere. Who's at closing? What are the parties that are at closing? Well, primarily, it's going to be the buyer and the seller, and a closing agent or escrow officer. Nowadays, it's mainly the title company, especially here. The title company has to be there. They close. That's it. Now, other parties that who might be present, include the title office, attorney, brokers or agents, or lender's rep. So it's not actually necessary for any of these parties to attend the meeting, but they can be present. You guys, if you rep the seller, be there. If you rep the buyer, be there. I'm just saying, it's a different feel. So at every closing, I just heard about actually yesterday during an interview, I was hearing about a story of an agent that shows up just like, hey, where's my check? Like, that's the wrong attitude to have. Like, I've been there for you. I want to sit. Like, you guys, you're going to lose another, I don't know, on average in 1 hour. But it could be 2-3 hours. It could be 6 hours. I get it. But you're walking away with a $10,000 check, for instance. Right? Just be there with your client. And then you're showing that support from beginning to end will also give you a repeat client and referrals. If they liked it, if they liked your presence throughout the whole process, that's it. It's a no-brainer. Now, if you're there and say, hey, you guys closed, great, where's my check? If that's your attitude, right? Like Nina, that's why I said, Nina, you're not getting your license anymore. Then that will hinder your transactions. Arlene, I just got your message. Thank you so much, and I'm glad you're able to get in. Don't forget, try to type questions in the Zoom chat, okay? Not in the WhatsApp. But thank you for joining us. Now, the closing process itself. The closing process consists of the buyer and the seller verifying that each has fulfilled the terms of the sales contract. So I said, as a seller, this is what the buyer needs to do. And the buyer said, as a buyer, this is what the seller needs to do. So we stipulated, that's the meeting of the minds, what each party has to comply with. If they have, then the mortgage loan, if any, is closed, and all the expenses are apportioned and paid, and the considerations exchanged for the title. The final documents are signed, and arrangements are made to record a transaction according to local laws. So usually, this is the closing process. We put an offer, and from the offer all the way to that closing date, the contract is executory. If you guys remember, executory, it's pending, right? Once we get to that closing date, it's still executory. We're going to verify that everything has been done. There's the mortgage approval, not a pre-approval, it's the final approval, so the commitment. We're going to verify the inspections have been done. So we're going to go over all the documentation again and make sure, boom, it's here. Great. Then we're going to close the loan. Right? What is closing the loan? Closing the loan is, let's say Bank of America is the one funding the transaction. Bank of America has to send the money, wire the money to the closing escrow. The closing escrow agent could be the title company. Once the money reaches the account, we have closed the loan. That's the first closing that happens if there is financing. Then what will happen is the mortgage, I'm sorry, the title company or the escrow office, whoever's handling the transaction, will disperse the payments for the expenses, exchange funds, and title. So now what we're doing is whatever's left goes to the seller, and then title goes to the buyer. This is all happening before you sign anything, right? Even though the payment did not go out right there and then, but we already have the criteria of who's going to get what in the transaction. That's what we're doing, right? And at this point, we complete, I'm sorry, that's what we're doing here. And at this point, once that is completed, we complete the documents, which is signing everything and saying, hey, you are the proud owner of this property and you are released of this property. After closing, all documentation goes to be recorded in your county recorder or however it is in your local area, okay? But that is the process. It's a very simple process. Confirm everybody did whatever they needed to do. Confirm there's money. All right, that's what it is. Close the loan. Pay everything, meaning allocate or apportionate the monies already. Whatever's left is what goes to the seller in exchange for the title. We complete the documents at this point by signing them and recording. Simple process, right? You guys agree? Thumbs up? Great. But we're just on the second page of this chapter, so it's not that simple. There's way more to come. So, what happens at transfer of title? Guys, if you have any questions as we go, just drop them in the chat, whether you're on Zoom or YouTube. So the seller must produce evidence of marketable title, such as a commitment for title insurance by a title insurer. Before making the title commitment, the title company performs a title search to discover any liens, encumbrances, restrictions, conditions, or easements attaching to the title. Now, question. What are liens, encumbrances, restrictions, conditions, or easements? I mean, they're all encumbrances anyway. But what are these? What is a lien? Can anybody tell me in the chat, what is a lien? Let me know in the chat. What's a lien? Very good. Financial claim. Great. What that means? Unpaid money, right? Something needs to be paid, and they put a claim against the property in case you don't pay. Great. What about easement? What is an easement? Easement. Who remembers that? Waiting. Easement. Wow, this was day 2. This was like 100 years ago. I mean, 3 weeks ago, 4 weeks ago. Easement, the ability to use your neighbor's property, an interest in your neighbor's property. Okay. It's the right to use. It's not the ability, it's the right to use. Guys, easement is a right we have on somebody else's property. Easement is a right that we have on somebody else's property. There's easement appurtenant, right? That means there's 2 properties connected to each other, and you have the right to cross the other property, or so your neighbor's property, for something. For instance, a shared driveway, right? If you have a shared driveway, I'm not gonna say, hey, take the 2 wheels off your car, right? So you can only use your side versus mine. No. So shared driveway, I have a right to half your half, and you have a right to my half. So easement is a right on somebody else's property. Now, restrictions and conditions, these usually are stipulated by a homeowners association or a co-op, but the restrictions and conditions could also be stipulated by the previous owner, right? You guys remember this? Where I can tell you, hey, I sell it to you, but you can only use it for this purpose or that purpose. You guys remember this? Great. So all of this stuff is going to be brought up at closing. So everything we talked about in the first week is going to be brought up at closing. We need to know who else other than yourself has the right to the property, right? So if there's lien holders, they have the right to the property, they need to be paid off, right? If there's other types of encumbrances like restrictions, conditions, or easements attached to a title, they need to be addressed with a title company. Okay, so again, the seller is expected to remove these these encumbrances prior to the specified date of the contract, unless, of course, if it's an easement, you can't remove it. So the most common title cloud or encumbrance, you guys know cloud means encumbrance. The most common one is unpaid liens. That's the easiest one to remove, which is by payoff. Now, the seller might also be asked to execute an affidavit of title. What is an affidavit of title? Is we're swearing and subscribing. So we're putting on paper that we promise, as sellers, we promise that there's no issues with the property whatsoever other than those that we agreed to. So through the affidavit, through our promise, through our guarantee, I swear, right? It says right here that I have no new liens, no new judgments, no unpaid bills for repairs or improvements, no unrecorded deeds or contracts, no bankruptcies or divorces that would affect the title or any other defects that the seller is aware of. Through this affidavit, again, I am promising that none of these exist, but if they do show up in the future, title company or buyer, you can come after me. That's what it is. We are promising that there's no issues. But if an issue shows up that we did not disclose, you can come after the seller. So this happens with almost every transaction. There has to be a promise that there's no issues. Okay. Okay, the buyer should inspect the property, and I think this is common sense, so I'm going to go right through this. But should we do a walkthrough? Should we look at the property right before closing as buyers? Absolutely, to make sure that it's in the condition that was promised to us or that we saw originally, right? Again, seller must pay off the bills, so they have to call every single entity that they owe money to and say, hey, give me a zero balance. Like, what is going to be to take this to a zero balance bill? It's called a payoff statement. And we're going to call the mortgage company. We're going to check the taxes. We're going to check the water bill or sewer bill, whatever it is. Any unpaid bills against the property must receive a payoff statement so that at closing, we pay everybody off out of the proceeds of the transaction. Okay. So after everything is verified, it says finally the seller produces and/or deposits with the escrow agent the deed that conveys the property to the buyer. The buyer at this moment produces what? The rest, the earnest money which they had given before, the loan funds and documents, and then any other cash needed to complete the purchase. All right, skip all this, and then right here. What is the broker's role? Okay, who's the broker? You are, right? Because you're an agent of the broker, so therefore you are the broker, you are the broker's rep. So you are. What is your role in this whole thing? So the broker usually continues to provide a service between the signing of the sales contract and closing by helping to make arrangements for pre-closing services such as inspectors, surveys, appraisals, repairs, and generally taking steps to ensure that the closing can proceed as scheduled. As I said earlier, you're like the maestro, you're like the coach. You're the one that's organizing the whole thing and making sure we get to the closing. So you're the one that make sure that everybody's doing their part. You're not doing the work for them, but you're making sure that they're doing their part, okay? So that's the broker's role. A broker may conduct proceedings at the closing meeting or may have no further role in the transaction after the sale contract is signed. So depending on the local practices, the transaction and the transaction in question, and in many states, the broker is charged with the responsibility for accuracy and timely delivery of closing documents. Again, it might be on you to, again, make sure everything is in order. So you're collecting all this information, right, for the principal parties. A broker may also have the responsibility to report to the IRS. Now, the good thing is that nowadays, the title companies and attorneys, they usually report to the IRS. So brokers don't. In this case, will never be you as a salesperson, but it could be your broker. All right? All right, we got 5 people watching on YouTube. Let me know that you're there. If you have questions, drop them in the chat. Now, for Real Estate Settlement Procedures Act, Real Estate Settlement Procedures Act, or RESPA. We talked yesterday about, we've talked about Regulation Z and we talked about TILA, right? If you guys remember that, and we're now talking about RESPA. What is RESPA? What do you guys remember of RESPA? Because we already talked about this in financing. What do you guys remember of RESPA? What is RESPA all about? Let me know in the chat. What is RESPA all about? Waiting. What is RESPA all about? What is settlement? Holger says procedures. Yeah, well, there's procedures to it. But what is a settlement? When we settle, that means we're done, right? So the translation here is closing. So every time we see settlement for real estate transactions, we're talking about this chapter, closings. So RESPA is an act that says how closings should happen, right? So Real Estate Settlement Procedures Act, or Closing Procedures Act, right, is about closings. Now, RESPA integrates now, since as of October 3rd of 2015, RESPA integrates in GRID. Hey, Miss Solomon, I'm sorry I did not see your message on time. Never retract an answer or delete your answer, because right or wrong, throw something. I'll explain why it would be right or why it would be wrong. So there you go. Real Estate Settlements Procedures Act, okay? So just so you guys know, whoever's watching on YouTube, the rules of engagement are easy, just like I do here in the Zoom, is throw whatever answer. If it's wrong or if it's somewhat correct, I will still explain why or what it will be. And if it's correct, I'll acknowledge that it's correct, okay? So never be afraid. Just throw whatever answers. It's fine. I don't judge YouTubers. I judge my students. So don't worry about like Nina is always asking like 1,000 questions per minute. Not even per day. It's per minute. No, I'm just kidding. But guys, definitely Zoom, YouTube, guys, always, and even those of you that have they're part of the school and the WhatsApp group, just ask questions. I don't care how ridiculous it might sound in your head. Okay, in your mind, it could be like this question is stupid, this question is dumb. Don't. Just throw the question. Nobody's going to judge you, because I bet, and you guys have seen, I mean, Nina's question, most of them have been very valid, but you guys have seen Nina posting questions, right? So do you think, I'm sure, Nina, there's some questions that you're thinking as you're putting them, like those 1,000 questions. I'm sure there's one that you're going to be like, should I even be asking this, right? Right? So you're acknowledging. Oh, it's Nirka. Okay, cool. So there you go. So it's not Jasmine, it's Solomon, it's Nirka. So Nirka, definitely ask the questions. You know how it is. You already know the rules. Anyway, so, but always throw questions, okay? There, even if I have to repeat it, like I always repeat, like, for instance, let's say Felix asks a question, and then later on Nina asks the same question, or later on Amy asks the same question. Personally, I don't mind, as long as you guys are, I see that you guys are paying attention. Personally, I don't mind. If I see you're not paying attention, I will also call you out and say, listen, I just answered that like 5 minutes ago, right? I'll call you out. So as long as you're paying attention and you're putting the effort, I love that, and I will give you, I'll always give you my all. I'll always answer to the best of my ability. Okay. So going back to this, what do we have here? TRID. So I told you that RESPA integrates now with TRID as of October 3rd of 2015, and this is in wake of all these the economy crash. The government said there has to be different sets of rules. So the government said, we think that one of the problems is there's too many forms, there's too many documents, too many disclosures out there, and people got confused of what type of loan they were getting into. So October 3rd of 2015, they decided to merge all forms. And that's what TRID is. TRID is a merger of the forms. It's not a new law, even though they made amendments to both the TILA and RESPA. They made amendments to it. They added a few things. But it's not a new law. TRID is not a new law. TRID is the Truth in Lending Act and RESPA integrated disclosure. So they merged all the forms into one document, which we now know as loan estimate. And then right before closing, they give you a variation of that loan estimate, which is now called closing disclosure. So these must be very similar. The loan estimate is literally me saying to you, hey, it's probably going to cost you this much, right? This is what we estimate that it's going to cost you, the loan and potential closing costs. The closing disclosure, the CD at the end, is literally saying, hey, remember those numbers we gave you before? We've adjusted everything, and these are the final numbers. If there's a huge discrepancy between these two, you can say, no, something is wrong, right? And we're going to talk about this in a little bit. You can say something is wrong. But if not, then we're good. You were expecting already the closing cost. You're expecting already this APR. You're expecting already to make this monthly payment. Now I'm going to show you guys. Everything is laid out in the CD. Okay? Now, the steps are very easy to remember. Because of TRID, the first thing you have to do is get an information booklet. Second thing is the loan estimates, which will come also with mortgage disclosures. Third thing is the closing. That's it. These are steps. These are 3 steps. That's it. Information booklet. We're going to go over that. Is when you give the loan estimates to, when you apply for a loan, I got to give you a booklet that says your home loan toolkit. So this is what a loan is, and this is what you could expect. That's the first thing that's given at application. Within 3 business days, as we'll go over in a second, the lender has to provide you a loan estimate. And then within at least 3 business days before the closing, the lender must provide you with the CD. That's it. As far as closings, this is the process. So RESPA was enacted in 1974. And the purpose of RESPA was to clarify the settlement costs. So RESPA, just like TILA, its give or Regulation Z, is letting you guys know this is what you can expect, period. Everybody should get to the closing table knowing what they can expect of that closing. Like, how much do I have to pay? Very important. Now, RESPA applies, sorry, zooming in. RESPA applies or involves residential property. RESPA applies to residential property. So RESPA does not apply to commercial property. So residential property. RESPA applies to first or second mortgage lien. So purchases. RESPA applies to purchase. Or if it's being financed by a federally related mortgage loan, like FHA, VA, and so on. Okay? So what do you need to remember about RESPA? It's for residential property at time of purchase and for federally related transactions. Federally related transactions. Guys, good so far? Make sure you take a note on that. RESPA, let me go up. RESPA is about closing costs or settlement costs in residential purchases. Okay? RESPA, closing costs or settlement costs in residential purchases. And that's what you need to remember about RESPA for state exam. That's the key thing. There might be a question there. RESPA usually applies to, they give you 4 answers. Anything that's commercial, mobile homes, cash transactions, right? It doesn't apply to those. Then there's going to be one answer that says residential purchase or federally related loans, right? Which usually are for purchase of residential, right? So these are the potential question, the potential answers. So purchase of residential property could be a first or second mortgage lien at time of purchase for federally related loans. All right, next page. Like I said, on October 3rd of 2015, they integrated the forms. That's what it says, the disclosure requirements. And we used to have, these were the old forms. They're still used for everything that's not a purchase of residential, right? But it used to be the good faith estimate, HUD-1 settlement statement, right? And truth in lending disclosure. So there's 3 forms. The good faith estimate is the numbers. HUD-1 is the closing number, so the loan numbers. This is the closing numbers. And then there was a separate form, which was the TILA, or Truth in Lending Act disclosures, that says that you should shop around for loans. So there's actually 3 forms, not 2. There was 3 forms. And now these were replaced by the loan estimate, as I said, and the closing form at the end. A lender that's subject to RESPA must give the loan applicants the CFPB, or Consumer Financial Protection Bureau booklet, Your Home Loan Toolkit. And they must give it to you within 3 days of receiving the loan application. Let me just correct this. Business days, 3 business days of receiving the loan application. I'll let you guys know when it's calendar days and when it's business days. You need to know what it is. But these are business days. Okay. So you apply for a loan. So you apply for a loan. So you provide a loan application, and the lender must provide you with this disclosure. Now, it doesn't say here, but I'm going to tell you. Have you guys ever purchased any electronic? Raise your hand if you ever purchased an electronic. Great. Probably even purchased a car, right? If you've purchased anything that's manufactured, right, as an example, then it must come with what? With instructions, a manual, correct? Right? So here's the thing. Does the manufacturer have to explain to you everything that's in the manual? No. What they do is, hey, here's a manual. Read. That's it. It's there. It's included. Well, here, it happens the same thing. Lender must give you this home loan toolkit, but doesn't have to explain you anything. It's simply, oh, you applied for a loan? Here's a booklet. Read it. Now, agents, you are in a unique position to do what? To help the buyer, right, the potential borrower, to help the potential borrower understand trade-off between discount points and interest rates. Understand how the credit score affects your, because that's what's on the home loan toolkit. How the credit score affects the purchasing power, right? Help them understand the procedures of the loan. Help understand the different types of loans. Help them understand how shopping around different lenders could change the ratios, even though it's a 5% interest rate across the board, let's say. Bank of America could be 519 APR and Wells Fargo could be 524 APR. So the power of shopping around. All that information is in the home loan toolkit. So again, the lender must provide, but doesn't have to explain. You guys are in a great position to explain this to your client. And Nina disappeared, so probably one of the questions is, where can we find it? And the answer is Google. So Google, you're going to Google your home loan toolkit and you can get it. CFPB is Consumer Financial Protection Bureau. Consumer Financial Protection Bureau. And that's if you are, if somebody did something wrong to you financially, where like a company wronged you financially, what can you do? You can go and complain and say, hey, they defrauded me. They took advantage of me. Whatever it might be. Okay? So you can complain to them. Definitely get your home loan toolkit. I'm going to have soon a class where I'm going to have a mortgage rep explain the home loan toolkit. So it's good to have. It's good to have as a first-time home buyer type of class. So if you guys ever have potential buyers, or even for yourselves, and you want to participate in it, then go ahead. Just participate in the first-time home buyers event that we'll have, where we talk about all this good stuff. Okay. Nina, can you repeat again? The stream froze. Again? I don't know what you want me to repeat and where did I freeze. Did I freeze for the rest of you guys? No? Okay. Going to repeat again the CFPB, Consumer Financial Protection Bureau. Consumer Financial Protection Bureau. And that's where you can put complaints when a company, a creditor, wrongs you in a transaction. So if they took advantage of you, if they're charging unnecessarily high interest rates, if they deceived, you can go there. When is the event? I will announce. Everybody will receive an email and a text message. So I will announce it. I don't have it right now. A lot of things are still very iffy of how we're going to do it because of we're pending the state to make changes to this either online, or if we're going to have a hybrid, like people can be here and online, or if we're going to do, if I have to convert all our courses to virtual, then we will. Unfortunately, that we don't know yet, again, how it's going to be. Would I like to convert everything to online? No, I would like to have a hybrid style, be able to do online and in person, because everybody has different preferences. So there's a lot of courses, like some of you purchased this course, including a contract writing course. And unfortunately, the contract writing course is in person, right? We are converting it as we speak, converting it to online. But, you know, it takes time, and it's, you know, we're waiting for the whole change to happen in New Jersey, where we can go back to in person. Yeah, we're gonna have a few events. Hopefully, either towards the end of maybe end of November, beginning of December. There's a lot of events, and there's a lot of trainings that are going to be available as of January, that I can guarantee. But some of the stuff, like, people are asking me for the broker's course as well, and do it strictly online. It's different than the salesperson. There's way more to it, and some of the stuff I'm more like hypothetical versus black and white. You know, like these are black and white, the laws, like boom, the basics, right? For a brokerage, it's the basics, so we go over everything else, and then there's the part which is understand marketing, right? Understand how to send an email, understand how to address your team, understand how what is a franchise and what is a non-franchise agency. So it's not like the black and white. It's hey, what would you like to do with your agency, right? So it's a different feel to it. Here it's easy, like it's black and white. It's the law, and I can give you examples of it. Everything else is like brokerage and first-time home buyers events, contract writing. Even contract writing is like black and white. It's right there. But I gotta give you so many examples of different types of contracts for different situations, that just doing it online has been a little difficult for us, based on the way we teach the contract. So again, when will the event be? You guys are on a mailing list, so whoever's on our mailing list will always receive communications from us regarding future events. So don't worry. Any course that we open up, any events that we do, any sponsorships that we can recommend, we will let you know through email and text message. Okay? Cool. So back to this. We already told you that as soon as you complete the loan application, you must receive what's called your home loan toolkit. Got it. Out the way, right? Now, once you receive the application, besides the home loan toolkit that must be given at the application, the lender has now 3 business days from application, completed application, not just application, completed application, 3 business days to provide what's called a loan estimate. So thank you for applying with us. We've reviewed all your information, and this is what we pre-approved you for. If you choose to move forward, these are most likely your terms. That's what it says, right? And again, these terms are going to be restated in the closing disclosure. So right before the closing, you're going to have the same document, the LE, which is now called CD, includes 1 or 2 more pages, because now it's the final numbers. Okay. Now, under CFPB rules, or Consumer Financial Protection Bureau rules, a lender must use a closing disclosure to disclose the settlement costs to the buyer. So this form covers all the costs that the buyer will have to pay at closing, whether to the lender or to the other parties. The use of this form enforces the RESPA's prohibitions against lenders requiring a buyer to deposit an excessive amount of tax and insurance escrow. Felix, H24 and H25 is the LE and the CD respectively. So that's just under TRID. Okay, under TRID, the form is form H25. A loan application, for instance, is a 1003. These are just the form numbers. H24 is the form number for the loan estimate. But don't, like, guys, that should not be a main concern for you at all. Right? Nobody goes around and says, hey, do you have the H24? No. You're going to say, hey, do you have the loan estimate? Nobody goes around and say, hey, do you have the H25? No. They're going to have, hey, where's the CD? Simple. So don't get too distracted with H24, H25, or even the application, which is a 1003. Don't. I know it because I have to teach it and because I do it, right? But it's not something that they have to know for the exam. All right. Right now, my focus for you guys, even though I give you extras, my focus for you guys is what do you need to pass the exam? Everything else will come along as you practice. Okay. So the consumer must receive the CD no later than 3 business days before the closing. So the consumer, the borrower, must receive the CD, or even the seller, they have the copy of the CD as well. They must receive the CD at least 3 business days before the closing. It's not within 3 business days of closing, it's at least 3 business days before the closing. They must receive it. Gotta remember this. So again, at the time of application, home loan toolkit. That's number 1. Within 3 business days of application, so no more than 3 business days from application, you must receive the LE. That's number 2, right? And any disclosures. And right before closing, at least 3 business days before closing, must receive the CD. That's number 3. Those are the 3 requirements for the loans. And this is not just for state exam. This is real life. So why do we need to receive the CD before closing? Because again, it tells us all the fees that will come in the connection with the closing. So I have 3 business days to do what? Oh man, instead of 8,000, I need to bring 8,500. I need to figure out $500 more for the closing. You understand? It gives you enough time to review everything, make sure everything's in order, and that you have enough money to close. Okay, until October 3rd, 2015, in New Jersey, Referrals was 1 business day before. So imagine the day before. Let's say we're closing on Saturday, and you have the document on Friday or Thursday. Let's say. Where are you going to have the time to figure out another $1,500 or $2,000 or whatever? Where are you going to have the time to find that? You got to get out of work. You got to make some calls, or maybe you do have in the bank account. You don't know. But if you don't, you're expecting an amount, and now it's a different amount, right? So these are the things that were corrected with this 2015 law. Now, limits on escrow accounts. Every time you see escrow for closings, right? Escrow for closing, not the escrow for the broker. Not the escrow for the broker. This is for either closings or, and they will stipulate that in the question, okay? So there's the escrow for closings or financing. Every time you see escrow, we are talking about tax and insurance. And escrow is going to be reserves. Okay? So with every loan nowadays, the lenders, they're not obligated to, but they can request for you to put some money aside towards taxes and insurance at the time of closing. Like it's like a prepayment just in case, right? And then with every mortgage payment, they include principal interest, right? Usually, and then taxes and insurance. So That is, every time you see escrow or impound, is also called impound, right? Escrow or impound means taxes and insurance. So I'm giving you, again, all the terms possible for you to remember in the state exam. When you see one thing, automatically relates to the other. That's what we're trying to say. As soon as you see the word impound or escrow reserves, right, they will put either reserves or putting money aside or something like that. Every time you see escrow or impound, automatically taxes and insurance. Look for the answer that talks about taxes and insurance, right? Or if they, in the question they put taxes and insurance, as soon as they bundle these two, automatically look for answer that says escrow or impound. That's it. There's no ifs or buts about it. Escrow, impound, insurance, tax. That's it. Okay? And again, escrow, taxes, insurance. Okay? That's it. RESPA prohibits payments. So these are called referral fees and kickbacks. These are illegal. These are illegal. Okay? Referral fees and kickbacks, they're illegal. And RESPA, this is Section 8 of RESPA. Not that you need to know Section 8 specifically, but Section 8 of RESPA says, hey, mortgage company, I'm referring to you a client, right? So you have to give me back X amount of dollars. No, RESPA clearly says we prohibit the payment of fees as part of a real estate settlement when no services are actually rendered. So by referring somebody to the mortgage company, what service did I provide? Nothing. Now, if I did part of the mortgage, or I'm licensed as a MLO, mortgage loan officer, that's a different story. But here it says clearly, this prohibition includes referral fees for such services as title search, title insurance, mortgage loans, appraisals, credit reports, inspections, surveys, and legal services. Now, guys, here's the thing. I have my team. I have MLOs. Usually they have their own appraisals. Inspectors, surveyors, attorneys, title companies. We have the team. I can recommend that you use some of these people, right? But can I get paid by them? Can I get some kickback? Answer is no. Okay? You guys understand? For RESPA, for real estate settlement, residential purchases, the answer is no. Okay? Now, what it says here is I can have, like I said, business relationships and affiliations with other real estate firms, mortgage brokers, title insurance firms, and other such companies are involved in the transaction. These are permitted. Business relationships are permitted, like I was just saying, provided that the relationships are disclosed in writing to the consumer and the consumer is free to go elsewhere for the relevant services, and the companies do not exchange fees for referrals. So can I recommend people to you? Yes. Can I get paid by them? No. Not related to the transaction. Can I have a mortgage company pay part of my marketing? Sure, that's a business relationship. Can I have a title company have a resident office here? Sure, but that's not paying per service. It's not a referral fee. Do you understand? They're paying for office service, not a per transaction service. So it's not like, hey, I got you Nidia, so please give me some money. No, that cannot happen. You cannot get paid per transaction. Same thing as unlicensed salespersons. They're either employees, right, and they get paid a salary, or they're independent and they get paid commission, meaning they're licensed independent, get paid commission. What if they choose to compensate you for your referral to show appreciation without you actually asking for it? Can you accept? Look, There are limitations, Felix. That's a great question. There are limitations on that. New Jersey Department of Banking and Insurance, for instance, talks about gifts of no more than $25. Right? If the compensation, hey, I just made $3,000. Here's a ticket for you to go to Bahamas on vacation. Right? That's not $25. Does it happen? Yeah, I've heard that happen. Is it legal? Technically, no. If I'm in the business, or if I'm the type of guy that is, I'll give you the example. My partner has a timeshare, and he's always traveling every year, twice a year. Sometimes I think 3 times a year. Too often, right? Too much. But he's always traveling. And he offered me in July, he says, hey, listen, borders are open. You want to go? Him offering me besides being partners, that's different. But let's say I was providing a service. I'm an MLO, and he offers me, hey, listen, just let's go to Dominican Republic. Let's go. Or Jamaica. I think he went to Jamaica. So let's go, right? Him offering me as, hey, I appreciate you, man. That's what it is. Not a problem. But again, if he's doing that related to the transaction, that's illegal. Okay? If that travel voucher says, hey, this is for Nidia, client that closed on whatever, that's illegal. If I happen to offer, like, be a person that gives gifts to other people as appreciation, not illegal. It's just my way of being. Do you understand the difference? Per transaction, no. If it's a normal thing, if it's just a random appreciation, that's different. I appreciate doing business with you. That's it. Okay? Thumbs up? Great. So, can I receive compensation for referrals? No. Can I receive appreciation for having a great business relationship? Sure. Got it? Like, I'll give you an example. I have a mortgage company, and once in a while I get a $5 Dunkin' Donuts gift card. It's personalized, so I know they spend another $5 to get it. So a whole $10 appreciation token. So I'm happy. I mean, as long as they take care of my clients and I get to close, I'm already getting paid. So I really don't care about how much is in that gift card. $5. All right, Felix, go ahead. You have a question. All right, there's 5 people watching on YouTube. Let me know you're there. Let me know if you have questions. Throw them at me. We are live right now. So go into the chat and chat with me. So you can get compensation on a referral, but it cannot be more than 25 compensation on the deal. We can give gifts even to our clients. Congratulations on the purchase of your house. Here's a gift, but no more than $25. So even to your clients, you can give gifts. Yeah. Okay, guys. Whatever you want to think, it's not worth it. Bottom line, jail time or losing your license or anything like that is not worth it. So forget the $25, forget any gifts, forget all that. You want to do it out of your goodwill and say, hey, client, congratulations on the purchase of your house. Here's something for your house. Do it. Okay? You want to invite the mortgage person that helped you. You want to invite them for lunch. Say, hey, I really appreciate you. I'd like to invite you to lunch. Do it. Right? But don't try to figure out what are the limits, what we can do or not do. Like, listen, just do it as a natural course, not as a, oh, I can get compensation if I refer to you. No. Okay? So that's the bottom line here. All right. Financial settlement of the transaction. So here, it says financial settlement of the transaction. I'm going to go over the settlement process, the selling terms and closing costs, debits and credits. And debits and credits means minuses and minus and plus, right? Debits is minus is when something's taken out of your account. The plus is a credit when something's added to your account. So every time you see debits and credits, it's minuses and pluses. Now, here's the thing. It also talks about non-prorated items and prorated items. Non-prorated items are expenses. We're going to go over this in a little bit. Expenses only. Okay. Prorated items are adjusted debits and credits. The seller and buyer. Sorry, not to. Actually, between. Okay, so prorated items are adjusted debits and credits between the seller and the buyer. Non-prorated items are expenses only. So like attorney fees. We pay attorney fees if we hire an attorney. Prorated items are stuff that the seller paid for or has not paid for, and the other parties, the buyer is going to either benefit or have to pay for it. So they are adjusted to reach zero on the day of the closing. Okay. So, settlement process. Settlement process consists of 5 basic steps. We're going to figure out the selling terms and closing costs. What are selling terms? Selling terms are what we agreed to pay, what were the deductions, commissions, and all that stuff, right? Those are part of closing costs as well. Then determine what's expenses only, determine what's credits only, determine what needs to be given to the seller or to the buyer, complete the closing statement, and then disperse the monies to whoever needs to receive them. So the selling terms and closing costs, I'm going to show you that in a little bit. Let's go straight to debits and credits. Again, a debit is a minus. So that's an amount that one party must pay. A credit is something that you must receive. So it's a plus to your side, something that you must receive at closing or already received prior to closing. So these are credits. So again, debits and credits. It's either received or receivable. It's a plus. It's a credit. Paid or payable. It's a debit to either the buyer or the seller. The excess of the buyer's debits over the buyer's credits, the excess of the buyer's credits over the buyer's credits is the amount that the buyer must bring to the closing. The excess of the seller's credits over the seller's debits is the amount that the seller will receive at closing. And then if it's an individual expense, then it's a debit for that party only. Individual expense, like attorney fees. This will make more sense in a little bit. An income or expense item that affects both parties is apportioned or prorated. So an income or expense that affects both parties is apportioned or prorated. So A prorated item is treated as a debit to one party and credit to the other. Prorated is a debit to one party and credit to the other. For, very important, for the same amount. Okay? So it's a debit, so minus 600 and then plus 600. Same amount. Why am I saying this? Because in the state exam, if you do have a question regarding this, it's as simple as knowing who must be debited, who must be credited, and look at the same amount. So there's questions that have, obviously they all have 4 answers, but let's say it's a credit to the buyer. Then you're going to look for the answers that have credit to the buyer, and the ones that say credit to the seller, you knock them out the park. Like these we don't want. Like you knock them out, you cross them off. We don't want these. So you eliminated already 2 answers. Then there's 2 answers that are very similar. They say credit to the buyer, debit to the seller. But then one has $600 and the other one has $900. If it's unequal amounts, that's not a proration. A proration or a prorated item must have the same amount. So knowing how to identify who gets the debit and who gets the credit is the key right here. And then looking at same amounts. If I take 600 from one party, I'm giving 600 to the other party and vice versa. You guys got it? Give me a thumbs up. Great, because we're going to go into examples in a little bit. These are some of the stuff that will be credit to the buyer. Earnest money, the good faith deposit, you already prepaid it, right? So it's a plus when we get to the closing, right? Because credits are plus. So when we get to the closing statement will show, well, yeah, you already put $5,000, so it's plus 5,000 here. The loan amount borrowed, so it's plus to the buyer, and the seller's share of prorated items that the buyer will pay. So if the seller owes you money, it's going to be a plus on your side. On the debit side of it for the buyer, right? It's the purchase price. So we have down payment plus loan amount usually reaches purchase price. That's going to be the minus. So debits minus. Expenses per agreement or custom, like per agreement, attorney expenses. Per agreement, seller or buyer agreement, expenses. Custom, like title search, that's on you. Appraisals, it's on you, that's on for the buyer. And also the buyer's share for prorated items prepaid by the seller. So if the seller already paid taxes, right, and we're in the middle of the year, then the buyer is responsible for the taxes for the end of the year. So the buyer has to pay half of the year's taxes, has to be adjusted. Okay. For the seller, for the seller's debits, right, again, minuses. These are expenses, again, per agreement or custom, like attorney fees again. Seller's share of prorated items that the buyer will pay. So it's a minus on the seller's side because it's going to be a plus for the buyer. And the loan balance or other lien to be paid off. So I received $300,000, but I got to pay commission. I have to pay, let's say, a title search, a realty transfer fee. I have to pay X amount of dollars to the buyer. And I have to pay $100,000 to pay off the balance that I have with Bank of America. So this is minus, 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 right? And that will give us the how much the seller is going to walk away with. What's going to be plus in the statement? Guys, I'm going to give you a live example in a little bit. What is going to be plus in the statement? The purchase price, right? Because the whole purchase price comes to the seller and then we deduct everything. So the purchase price that the buyer is paying goes to the seller as a plus. And again, then we deduct all these things from the purchase price. If the buyer owes any money to the seller for prorated items, so stuff like I said, taxes, the seller prepaid taxes, so the buyer must give credit to the seller. Now, non-prorated items are called expenses only. And on the buyer side, if you guys can see, the buyer usually pays, everything's negotiable, and then according to local custom as well. The buyer usually pays for mortgage recording fees, documentary stamp tax, so to record the documents, intangible tax on the mortgage, we'll talk about that later, mortgage related fees, like the buyer usually pays for appraisal, for credit report, for surveys, for the loan, impound reserves. Do you guys remember this word, impound? Oh. Impound means escrow. I just said that a couple minutes ago, right? Escrow, and that's taxes and insurance. Every time you see impound is escrow, is money put aside for taxes and insurance. And of course, attorney fees. What the seller usually pays is the stamp tax on the deed, so the recording or release of deeds or realty transfer fees, right? Title insurance, brokerage fee, so the seller usually pays for the broker's commission, inspection fees, title related expenses, and attorney fees. These are traditional expenses, which then will go based on agreement or local custom. So we're going to talk about prorated or adjusted. I'm writing it again. Prorated or adjusted items. Okay, Ninja disappeared. There's a question coming. Even though I don't see a question mark, but I know that's what it is. The seller has to pay for the buyer's inspection, depending. In some areas of the country, the seller also has to pay for title search. So again, like I said, it depends on agreement or local custom. As of right now, we're talking about general closings, right? What it is across the U.S., what could happen across the U.S. So that's why it says here, it says usually. Usually, right? Every state has their own thing. State of New Jersey, the buyer is responsible for inspections usually. But look, so let me go here. The seller is responsible for city inspections, right? The CO, the certificate of occupancy, is on the seller side. So inspection fees could be that. The buyer will have their own inspections to do. You got it? So these are a few things that could happen. Can the seller say buyer responsible for all inspections? Even city inspections? Sure. If the buyer agrees to that at the offer, right, then the buyer has to pay for it. So a lot of this stuff, again, is by agreement. This is what we usually pay for, usually. Can we say the buyer pays for the commission instead of me? The seller? Sure. Again, agreement. All right, so let's talk about prorations or adjusted items, and then we're going to take a quick break. When we're talking about adjusted or prorated items, we're talking about giving money to the seller or giving money to the buyer, taking money from the seller or taking money from the buyer. If it's an item that was paid in advance, so prepaid items paid in advance, then the buyer must reimburse. Okay? So prepaid items, the seller prepaid something that the buyer must reimburse the seller. Right? So prepaid items, remember, prepaid items, seller. Prepaid items, seller. And the buyer must reimburse the seller. So prepaid items, seller already paid. Like taxes, for instance. items that are in arrears or unpaid. Unpaid. Okay? Items that are unpaid or in arrears. If they're unpaid, then the buyer receives credit for unpaid items. If it's unpaid, like water bill, for instance, taxes, unpaid taxes, then who's going to have to pay for it? The buyer is. So the seller must credit the buyer. So again, the buyer receives a credit and it's taken from the seller. This is a good example of items paid in arrears or advance. Okay. Items that usually are unpaid. Taxes, usually. Taxes, because they accrue until the actual closing, right? Mortgage interest accrues until the actual closing. So if the buyer is going to take over the mortgage, then it's unpaid usually. Rents received by the seller, usually they're paid in advance, and then utilities usually are unpaid as it's being used. Charging shares. Okay. So if the seller has paid the buyer's share of an item, then the charge must charge the buyer. The buyer for the buyer's share of the period. If the buyer will pay the seller's share of an item, then we need to charge the seller for the seller's share of the period. If the seller has received the buyer's share of an income item, then charge the seller for the buyer's share of that period. So let's figure out who gets charged real quick. Seller paid for the year, right? So it's prepaid. So seller paid for the whole year. So we're going to charge the buyer for the buyer's share. So if I prepaid the whole year, right, then I need to charge the buyer for the remainder because the closing was August 7th. You guys with me so far? Give me a thumbs up if you're with me so far. Okay, great. So again, the seller prepaid the whole year. Let's say it was taxes for the whole year. The closing happened August 7th. Should the buyer benefit from the rest of the year? No. So the buyer has to compensate the seller for that difference. So we're going to calculate everything from here to here, and the buyer must credit the seller. Okay? If it's something that the buyer will pay for the month, so it's unpaid, we're going to charge the seller. These are just examples. So if it's for the month, the closing happened again on the 7th. So from the 8th and on, the buyer is the one that owns the property. Okay? If it's something that it's unpaid, like the bill is a monthly bill and the seller still did not pay, let's say water bill, right? Then the seller is the one that must credit. So we're going to figure out how much did the seller use. We're going to figure out the 7 days, and these 7 days must be paid to the buyer. So we charge the seller with that share. Give me a thumbs up again. Okay, good. Eldon, no? Okay, so I'm going to give you numbers right now. Okay? I'm going to give you numbers right now. So all we're saying is who must pay what. So actually, let me ask you something, Eldon. And I'm not sure if somebody else raised their hand, but let me ask you something. You own the home, right? And let's say you have a tenant there, and I buy the house on the 7th, right? That's when we close. You have a tenant. If you already received the month's rent, you're the seller. You already received the month's rent, and I move in on the 7th as the new owner. Should you keep the whole month's rent? Of course not, right? Because you were there for 1 week, I'm the one that's going to be there for the remainder of the month. So you need to give me 3 weeks worth of rent. You keep the 1 week because it was the closing was until 7, right? You keep that 1 week. Now let's reverse it. Let's say that the tenant still did not pay the rent. And I get paid the rent on the 15th. I'm the new owner. I get paid on the 15th, the rent for the whole month. Now, Elda, let me ask you. Because we're already closed, you're no longer here, am I entitled to keep the whole month's rent? No. So I must give you 7 days. I must give you 1 week. Do you understand? So these adjustments are who benefit from what until the day of the closing. Who benefit from what? So in this case, the seller paid something for the whole year. So the buyer must pay the seller the difference. Must pay the seller for August 8th and on, must give the seller credit for that, just like the rent that I just gave you, right? Here's the same thing. The buyer will pay for something that the seller did not pay yet, like a water bill, like I was saying, right? So in this case, the seller will be charged that 1 week of whatever the bill is, and the buyer takes over from this day on. Good? Great. All right, cool. So, let's see what time. 2 o'clock. We're going to have a bunch of examples here, right? So we're going to go over this in a little bit, all this stuff. Okay. So for now, what I'm going to do is give you guys a quick break. It's 12 o'clock. We're going to come back to computing prorations in a little bit. Hold on, because we have a question coming through from Felix. Is there a time duration when either the buyer or seller has to pay the expenses at closing? So it's the reason we're going to go over this, we're going to see the numbers, but the reason why we're doing this is so figure out today's the day of closing, right? From the proceeds, from the money that comes from the purchase or the sales price, right? From that money, it's adjusted who gets what, right there and then. It's not in the future, hey, give me in the future. No, no, no. Right there and then, we're going to determine who gets what and who has to pay what. It's at closing. You guys got it? Cool. All right, before I go to break, by the way, Felix Cham is upset at you. I forgot to tell you. All right, guys, we're going to go into a quick break. We'll be back 12:10. And I'm joking, Felix. He's not upset. All right, we'll talk.